This morning we continue to celebrate the music and the work of Dr. Winsford Joker Devine. He passed away yesterday. And, the irony is he and Sparrow made a lot of great music together. And for 15 years, they didn't have any sort of publishing agreement, any sort of copyright agreement. And they had to work through it and get to that point. And there was a lot of struggle and a lot of fight. And Sparrow has been noted to say that, he met the industry that way and he just figured it out as he went along. And a lot of people since then have been figuring it out as we go along. And recently we saw that the intellectual property has been up in question again because Trinidad and Tobago, I don't know, we don't seem to get it right. I want to welcome this morning Dion McNichol Stevenson, who's a creative industry consultant and entertainment lawyer as well, and also an adjunct lecturer at the University of the West Indies. Also, I want to welcome entertainment attorney and IP consultant Akila Phillip. This morning we're going to discuss what this whole thing is about and how we can find a way forward to secure our cultural heritage, our cultural identity. What does that even mean? Good morning, ladies.
Hi, good morning.
Good morning. Good morning, Rokas. Good morning, Trinidad and Tobago and all listeners. Hi, Akila.
Hi, Dion. Hi, guys.
So happy all right, so ladies, let me start with what is your intellectual property? Akila, can you tell me how do you define what your intellectual property is?
Simply put, it's a creation of the mind put into a tangible format. It needs to move from an idea to an actual concept. So it needs to move out your mind into something that you can actually identify, whether it is a sketch, whether it is a drawing or any type of prototype. It just needs to move out of your mind and into a tangible format. That's the simplistic way of describing it.
So tangibility is important.
Oh, yes.
Yes.
Fixation is a must. And, yeah.
All right. Now, for a situation like culture and things that are related to culture specifically, so the culture of our people, so the Juve situation that has come to light recently. Dion, is there any way that we can find tangibility in that, or do we have to recreate the definition to be able to say that Juve is intellectual property?
Okay. So that introduces a developing area of intellectual property, which is known as traditional knowledge or traditional cultural expressions. Mm-hmm. So, as you rightly put it, our traditional cultural expressions and our traditional knowledge may not always be in a tangible form. Sometimes it's passed down orally. I mean, you just described a situation where, that was the case, for some time with our Calypso. But that can find IP protection in terms of the existing IP systems in copyright. Other things can also find other forms of traditional knowledge or traditional cultural expression can find protection in the existing IP systems through patents or even trademarks. Or geographical indications. But that is a wide area that is traditional knowledge and traditional cultural expressions, which the WIPO, World Intellectual Property Office organization, is they continue to try to develop to have one entire internationally applicable system of protecting traditional knowledge and traditional cultural expressions.
Good morning, Dion. Good morning, Attila. This is Natalie. How are you all doing?
Good morning. Good, thanks.
We're doing well.
So I've been listening to the conversation, and of course, I was busy behind the scenes trying to look up, if you can trademark a word or copyright a word. And now you just introduced to me the idea of traditional cultural expressions. The question is, can the government, copyright or trademark the word Juve or even soca or calypso, these things that are considered traditional cultural expressions?
Well, I mean, I think there can be forms of protection, whether we desire as the holders of the TK or the TCEs, i.e. traditional knowledge or the traditional cultural expression. We have to decide, those of us that consider ourselves the holders of it, we have to decide where do we want it to be reposited, where do we want it to be held. So are we going the way of documenting our traditional knowledge and traditional cultural expressions and thereby having it, let's say, protected in the form of a database, for instance, which would attract its own copyright? Do we want to, I have been toying with the idea, and I know that it's also a discussion in other forums, of geographical indications for our output, musical output, such as calypso and soca, right? I know there's discussion around that idea for reggae as well. And that is really to be able to protect our cultural identity and preserve it, as well as have a commercial means of promoting it. Yeah, because of course,
but in the
meantime, in the course of trade.
In the meantime, though, what happens? What happens? Because we found ourselves, not for the first time, in this very uncomfortable position where we have something that we consider Trinbagonian, but somebody from the outside can take it. When it came onto the GPAN, it was somebody from inside, and this whole fight about whether or not a single person should own any right to any kind of pan. So what do we do in the meantime? Because here was somebody who was able to say, okay, I can patent this GPAN. What about the other pans? We see it on the outside where, you know, people are making pan, producing pan, claiming pan, when it was originated right here.
Right.
Interesting point, Natalie. And I just want to bring a little context in terms of, you know, the feeling and the sentiments within the country that something belonging to us has been taken. I just want to kind of refine it exactly in terms of where what the application is and the category in which the application was made and what was actually attempted to be done in terms of trademark, specifically within the category of alcoholic beverages. And that wide, broad brush of, you know, that everything was taken is not exactly accurate, because it doesn't depict what is happening in terms of what can be done moving forward with cultural expression and in terms of near and dear traditions within our society. So when you're thinking about the word was used and, you know, it's just taking something, yes, it's personal to us, but it is very specific in terms of what the application spoke to. And, you know, in addition to which, there are currently live applications within the United States for Juve under the category of recording performances. And when you see the definition, what happens is when you apply where a lot of persons had concerns, right next to it had foreign language, you have to go on to explain how that class that you're applying for, so let's see, it's Juve, and in the category I mentioned, recording artist, it says I open. So that is what it means. It means I open, and it means that that is what they're using for specifically in that class.
But Attila, if we had it down as traditional cultural expression or traditional knowledge, where it was somehow documented, would they still have been able to do that without our permission? Whether they're using it in a different way from we intended, like, you know, now it is attached to alcohol, when for us it's an expression of a freedom, you know, would it still have been able to be trademarked by them if we had, you know, somehow recorded it as Dion said, as some traditional cultural expression or knowledge?
I think we're operating in two different areas of intellectual property spaces. So in terms of whether the trademark would have been granted, once it would have followed the necessary rules and procedures, and there were no other commercial activity relevant to that specific activity the application was made in, definitely it most likely would have been granted. And once it did not refer to our traditional cultural expression as we know it, so if it was again made for alcoholic beverage without referencing what we know in Trinidad Juve to mean and the history and the culture behind it, it would have gone through the application stages.
All right. I just want to jump in here for a second. Dion, can you explain the difference to me between trademarking something and copyrighting something? Is there even a difference?
Yes, there is definitely a difference. Copyright refers to artistic expressions such as novels, films, music, and trademark is that distinguishing mark that is assigned to a mark or a device that is used in the course of trade. So you can have a copyrighted piece of material and never commercialize it, but a trademark specifies that you are, you know, the mark is being used to distinguish your good or service in whatever class that you're operating in, whether it be food and beverage, whether it be clothing and textiles, etc., from other goods on the market. So that's the distinguishing factor there. So a particular item or a particular creative expression can actually have both copyright and trademark protection in it.
So, for example, like Marshall Montano's Hui, for example, he could trademark that?
That can be trademarked as a sound mark, which is another form of mark. Again, it's a distinguishing feature that is used in the course of trade. That is the important factor there, that it is actually used in the course of trade.
Okay, so tell me, when you trademark something, how do you then, I guess, police the use of it?
Well, certainly you have to be. It's a personal obligation. So there's no outside authority, let's say, that is going to be doing that on your behalf. So when you register a trademark, as Akila said, it's territorial. So if I register a trademark in the US, I have to be monitoring the markets in which my trademark is playing to ensure that there's not enforcement. And if I do find enforcement, to act upon that infringement, to enforce upon that infringement. It's a personal right. And so you have to personally, or whether it's owned by an organization, they are responsible for enforcing their rights.
And I've also been hearing about something called global unique indicators. What are those? And do they cross the territories? Or is that something that is governed, that is applicable worldwide? Or because I mean, if it's called global unique indicators, I assume that it was, it will cover a wider territory than the trademarking would.
Well, I suppose that would depend on the context in which those terms are being used. So, for instance, we're in the digital age now, and you can have a song that is copyrighted, and there would be indicators that can be electronically input into them that are basically digital footprints that would identify that song played wherever, right? Now, I should mention also that copyright, unlike the industrial rights such as patents, trademarks, geographical indications, industrial designs, copyright is not territorial. So your copyright notice is a notice to the entire world that this is the person who owns the copyright in this. Mm-hmm. And we can see that when we look at how our collective management organizations that are responsible for music operate, right? It doesn't matter whether the song is played in Trinidad and Tobago or the song is played in Timbuktu. If it is within the repertoire of a collective management organization, there is that reporting, right, back about the use of the particular thing, and there are indicators that are used to make that more easily doable. In terms of global indicators.
Dion,
go ahead. No,
sorry, Dion, let me just see if I can reinforce what you said. So you're saying, like, for not Dion, sorry, Attila, you're saying that for the Juve is that if we use it in a specific way, or even the soca or calypso, that it can be trademarked outside if the meaning is different, if they're using it with a different meaning.
Yeah, and what you're really referring to is giving a secondary meaning to something that is known in everyday language. So if it is being used in a different manner or format, then you are able to have the trademark approved. It's the same way that we are using products and services now in the marketplace. Things like Monster, things like Apple, they're not known in the literal interpretation of what the word is, but the brand has been elevated to something else that has a secondary meaning and is now unique in the area of commercial activity in which it operates.
So legally, Michael B. Jordan could have used the word Juve for his rum.
Yeah, legally, he could have continued. He had already been granted the notice of allowance, granted that within the application, in terms of the foreign language, it wasn't clearly defined that it was for rum specific purposes, but he was already at the point of getting to the next stage of publication because he had gone through the objection stages, etc. And there are existing marks. There are marks that went dead actually on the USPTO's registry for Juve previously.
So even if we in Trinidad and Tobago somehow find a way to protect the word Juve, other people can still use it outside once it's not the shared meaning.
Once it's not the shared meaning, and again, it's a different concept. What Dion referred to is traditional cultural expression and knowledge. So we would be seeking to protect our culture, our heritage, and the way that we celebrate Juve. Somebody else using Juve, for example, as a stationary item does not impact in terms of what we know Juve to mean. So it's not like you can exclude a word from the dictionary totally. That is not really how IP works.
Mm-hmm. And I'm asking both of you again, how can the government what role does the government play in this in terms of protecting, our cultural heritage, whether it's the soca, the juve, the chutney, all of these other things that we do so well? How can the government protect them?
Right. So that would then, I suppose, fall to, if we're speaking about governmental agencies, that would fall to organizations such as the Intellectual Property Office, and perhaps Ministry of Tourism and Culture, and state enterprises that, and even trade, that utilize or have, more of a operational responsibility for our cultural expressions. And what that would mean is that we would have to develop and apply and implement policies that says, this is how we determine what our traditional knowledge is. This is how we're deciding to use it. And that brings us to another area of law, sui generis, which is basically a specific type of law developed to fill gaps for which existing laws create. So for instance, with traditional knowledge and traditional cultural expressions, you would find that some of our traditional knowledge, it's not fixed, as Akila said. So it's not expressed in a tangible form. So it may be difficult for us to protect it using existing systems. And therefore we would have to incorporate or develop new policies, new legislation that speaks to how we protect our traditional knowledge and traditional cultural expressions, what areas are going to be protected, etc. And yeah, I do agree that it is I think time for that to be subsumed within addressed. Let's say our creative industries policy or an intellectual property policy for the nation.
Yeah, I agree with Dion. And I just want to add, because again, as Dion explained, we have to rely on our existing systems of IP to really help bolster the traditional cultural expressions. And trademarks, I think would be a great segue into doing this right now based on what we have. If we identify these things that are near and dear to us, in terms of the words we use that are associated with festivals, to start having a very robust marketing and branding campaign to have those words as festivals and identified as festivals, where you can look at and say, okay, this is the brand, this is what it is, it's a festival, it's true, it's registered in these specific categories for services, etc. And that can be owned by a body or organization that manages it and monitors it. And what that allows us to do, because we have the international filing system available in Trinidad, in those countries where we have a presence, where we celebrate Carnival in various jurisdictions, we can have a heavy force monitoring how those festivals are being, the use of the words outside of anything that I would have mentioned before, for like a stationary product. If there's any intrusion into the use of the festival words in these particular places, we can then go in and say, hey, don't do that. We have a mark and a presence within these countries.
Right. All right, ladies, we do have to leave it there. We are out of time, but I want to thank you so much, Dion and Datila, for sharing your knowledge, and hopefully, the audience have a better understanding of, what we can protect, how we can protect it, and that if it's not used the way we use it, that it can be used by others outside. And maybe somebody in Trinidad and Tobago will start using it that kind of way so that we won't have these issues,
Yeah.
All right. Thank you so much.
Thank you for having us.
Everyone have a blessed day and stay safe.
Yeah.
Take care.
Yeah. Bye.